Grahak Sathi, 19th April 2025, Volume 5, Number 41. Why and how to make a will. Important things to know about making a will. A will is a document, a testament written by a living person, specifying how his or her wealth and assets should be distributed after their death. There is no prescribed form for it. You can write the will, sign it, and have two witnesses sign it in your presence. A person who writes a will is called a testator. Why you should make a will? You can control distribution of your assets. A will allows you to specify who receives, inherits your assets, property, money, belongings after your death. You can specify who gets what and how much of your wealth and assets. You can also specify who to give any gift and charitable donations to after your death. Prevents potential disputes. A clear and legally binding will helps prevent family disputes by clearly stating how asset should be distributed as per your wishes. Ensures care for dependents. A will allows you to name a guardian to care for any minor children in the event of your death. Without a will, a court will decide that. Appoint an executor. You can name a trusted executor, a person responsible for carrying out your wishes to manage your estate. Ensures your wishes are honored. A will ensures that your assets are distributed to your heirs according to your preferences. Facilitates easy transfer to beneficiaries. The legal heirs will get access to your asset quickly and easily. Who can make a will? The person making the will, the testator, must be at least 18 years old and of sound mind to ensure they fully understand the implications of their decisions. The will must be made voluntarily without any coercion, undue influence, or pressure from others. The law prohibits a person from making a will when intoxicated or ill, when they are incapable of understanding the consequences. It is necessary to register a will. It is not mandatory to register a will, but it is advisable to register it. When registered, it becomes an authentic will that will be safe with the registrar, where it cannot be tampered with. Registration also helps to ensure proper execution and prevent potential legal disputes. However, a valid will having later date, whether registered or not, is considered to be the last will and is valid in the eyes of law. What is a valid will? A will is valid when it has all the essentials mentioned in it, along with the proper intention of the testator. These essentials include the intention or the wishes of the testator with his or her details, details of the asset, beneficiaries and the executor, and signature of the testator, and proper verification in presence of two witnesses. How to make a will? Writing a will is a vital step to safeguard your asset and ensure that your wishes are respected after your death. By following simple steps, you can create a valid and enforceable will. Determine your asset. Make a comprehensive list of your asset, including property, bank account, investment and personal belongings in the following categories: movable properties such as cash, stock, etc. Immovable properties such as land, houses, apartment, jewelry, family heirlooms, etc. Also keep in mind any liabilities which would be adjusted against the overall asset while disturbing them as per the will. Distributing them as per the will. Specify beneficiaries. Identify beneficiaries who will inherit your asset and specify the exact share of each asset they are to receive to avoid any confusion or disputes. Appoint an executor. Choose a trusted person to be the executor of your will. The executor will oversee the process to ensure that the directions in the will are carried out. An executor can also be one of the nominees or a beneficiary under the will or any other trusted person such as a family friend, a lawyer or a chartered accountant. Draft the will. Write the will in clear and precise language detailing the distribution of assets, the executor's details and any specific instructions related to asset. Sign and witness the will. Sign the will in the presence of two witnesses who must also sign the will in your presence, attesting to the fact that you sign in voluntarily. The witnesses should not be beneficiaries to avoid any conflict of interest. Store the will safely. Keep the original will in a safe place, accessible to your executor and family members. Register the will. While not mandatory, registering your will with a register can help ensure its safekeeping and easy access after your death. Review and update. Regularly review your will and update it as necessary to reflect any changes in your asset, beneficiaries or circumstances. It is advisable to update the will after major life event, marriage, divorce, birth of child, new property, etc. Details to be included in a will. The name, age, address and other detail of the person making the will, testator, date when the will is made, declaration by the testator that he or she is of sound mind and free of any coercion and that the will is not made under any undue pressure. For an old person, it is advisable to attach a doctor's certificate certifying his mental health and sanity. The will should mention that all his previous wills are revoked. The details of name, age, address and relation to the testator of all beneficiaries as per the will. The name, age, address and relation to the testator of the appointed executor of the will. Details of properties and assets which are covered in the will should be listed. The share of the property asset that each beneficiary will get or the specifies of who shall get what is to be listed in full detail. If the beneficiary is a minor, then a custodian for the minor should also be mentioned in the will. If there are any specific directions in terms of executing the will, this should be mentioned. The testator should sign the will in presence of at least two witnesses. The witnesses do not need to know the details of the will. Full name, age, address and other identity details of the two witnesses should be recorded below their signatures. Other important points. A will can be revoked or altered at any time and as many times as the testator wishes before his or her death. It is very important to mention the date of making the will. The intention of the testator must be recorded in the will. Such declaration must also involve the manner of disposal of the property. All names should be written in full and should match those in an official document like Aadhaar or PAN card. Be as specific as possible about each asset, listing addresses, company or scheme name, account numbers, amount, etc. Each page of the will should be numbered and signed. Avoid using complicated or technical legal terms. What happens if someone dies without a will? If someone dies without making a will called intestate, their wealth is inherited by the heirs according to inheritance laws. Therefore, the distribution may or may not be according to the person's wishes. It could also lead to conflict and dispute about who gets what. What happens if an executor is not appointed? The court will appoint an administrator to carry out the responsibilities of the executor. Editorial team: Chairman CERC and Torch Praful Amin. Chairman CERS Walter Vieira. CEO Anindita Mehta. Associate Editors Anusha Iyer, Rashmi Goyal. Editorial Assistant Tithi Bhandari, Vandana Yadav. Address: Consumer Education and Research Center, 802 Grahak Suvidha Kendra, Sakar 2, next to Ellis Bridge Police Station, Ashram Road, Ahmedabad 380006. Phone number 079 3533 7262. Email address: complaints@cercindia.org. Helpline number 1800 233 0332. Dhwani Mudran Shanta Mehta Digital Talking Book Library, Anjan Mandal, Vasrapur, Ahmedabad 380015. Voice over by Anal Dave.